Links in the chain of custody. 1. Since it is called a chain, there must be links to the chain. The links are the people who actually handled or had custody of the object. Each of the links in the chain must show how he received the object, how he handled it to prevent substitution, and how it was transferred to another. Each of the handlers of the evidence is a link in the chain and must testify to make the foundation complete. This is the ideal way to show the chain of custody. 2. Jurisprudence identified the links that the prosecution must establish in the chain of custody in a buy-bust situation to be as follows. First, the seizure and marking of the confiscated drugs recovered from the accused. Second, the turnover of the illegal drug seized by the apprehending officer to the investigating officer. Third, the turnover by the investigating officer of the illegal drug to the forensic chemist for laboratory examination. And fourth, the turnover and submission of the marked illegal drug by the forensic chemist to the court. See People v. Kamad, 610 SCRA 295, 307-308 and cited in People v. Dahal, Gr. Number 212196, January 12, 2015. 3. Because of the definition of custody as defined by Sec.1 b of the Dangerous Drugs Board Regulation No. 1, Series of 2002, the movement of the drugs from one person to another must be duly recorded. Such record of movements and custody of seized item shall include the identity and signature of the person who held temporary custody of the seized item, the date and time when such transfer of custody were made in the course of safekeeping and use in court as evidence. Importance of the marking of the evidence. It must be noted that marking is not found in RSA 9165, as amended. It is different from the inventory taking and photography under Sec. 21 of the said law. However, long before Congress passed RA 9165, the Supreme Court had consistently held that failure of the authorities to immediately mark the seized drugs would cast reasonable doubt on the authenticity of the corpus delicti. People v. Dahal, Gr. Number 212196, January 12, 2015. Crucial in proving the chain of custody is the marking of the seized drugs or other related items immediately after they had been seized from the accused. Marking means the placing by the apprehending officer or the poseur buyer of his/her initials and signature on the items seized. Marking after seizure is the starting point in the custodial link, hence, it is vital that the seized contraband be immediately marked because succeeding handlers of the specimens will use the markings as reference. The marking of the evidence serves to separate the marked evidence from XXX all other similar or related evidence from the time they are seized from the accused until they are disposed of at the end of the criminal proceedings, thus, preventing switching, planting or contamination of evidence. People v. Dahal, Gr. Number 212196, January 12, 2015. The marking should be made immediately and in the presence of the apprehended violator upon arrest. The immediate marking upon confiscation or recovery of the dangerous drugs or related items is indispensable in the preservation of their integrity and evidentiary value. People v. Gonzalez, Gr. Number 182417, April 3, 2013. Effect of non-compliance with Sec. 21 of RA 9165, as amended. 1. In case there is a failure to comply with the requirements of the law in the handling of confiscated drugs, the law, as amended by RA 10640, clearly requires the authorities to show the following: a. The non-compliance must be because of justifiable grounds, and b. The apprehending officer team must have properly preserved the integrity and evidentiary value of the seized items. As long as the above are met, the non-compliance of Sec.21 shall not render the seizure and custody of the seized items void and invalid. Bar 2011. 2. Failure to strictly comply with the law does not necessarily render the arrest of the accused illegal or render inadmissible the items seized or confiscated from him. People v. Dahal, Gr. Number 212196, January 12, 2015. However, the prosecution must still prove that a. There is a justifiable ground for the non-compliance, and b. The integrity and evidentiary value of the seized items were properly preserved. Valencia v. People, Cr. Number 198804, January 22, 2014. DNA evidence. 1. In a case where the admissibility of DNA testing as a means for determining paternity has become the focal issue in controversy for the first time, the Supreme Court described DNA in the following words: DNA, or deoxyribonucleic acid, is a molecule that encodes the genetic information in all living organisms. A person's DNA is the same in each cell and it does not change throughout a person's lifetime. The DNA in a person's blood is the same as the DNA found in his saliva, sweat, bone, the root and shaft of hair, earwax, mucus, urine, skin tissue and vaginal or rectal cells. Most importantly, because of polymorphisms in human genetic structure, no two individuals have the same DNA, with the notable exception of identical twins. Augustin v. Court of Appeals, 460 SCRA 315. 2. Augustin has its roots in an action for support filed by a mother and her son against the latter's alleged biological father who denied having sired the child. The plaintiffs then moved for the issuance of an order directing all the parties to submit themselves to DNA testing pursuant to Rule 28, Physical and Mental Examination of Persons, of the Rules of Court. The defendant opposed the motion by invoking his constitutional right against self-incrimination. He, likewise, moved for the dismissal of the complaint for lack of a cause of action. The trial court denied the motion to dismiss and ordered the parties to submit themselves to DNA paternity testing. The Court of Appeals later affirmed the trial court. The Supreme Court, in upholding the order of the trial court and the Court of Appeals requiring the petitioner to submit himself for DNA testing, had the occasion to reiterate its earlier yet novel stand that DNA testing is a valid means of determining paternity. In Augustin, the Supreme Court briefly sketched its past decisions on DNA testing, which the court initially considered as not as accurate and authoritative as the scientific forms of identification evidence such as fingerprints. People v. Tehanke, 249 SCRA 54. The Supreme Court admitted in Augustin that, in early cases, the court's faith in DNA testing was not quite so steadfast in the previous decade. Earlier, in Pei Lim v. Court of Appeals 270 SCRA 1, also a case for support filed by the mother in behalf of her child against the supposed natural father, the court cautioned against the use of DNA evidence because, as a relatively new science, it has not yet been accorded official recognition by Philippine courts and held that paternity would still have to be resolved by such conventional evidence as the relevant incriminating acts, verbal and written, by the putative father. Consistent with the rulings of the era, the court, as well as the lower courts, decided against the defendant father on the basis of the incriminating letters written by him and not because of any DNA testing or similar procedure. 3. In 2001, however, the Supreme Court showed signs of opening up to DNA evidence, in Tijing v. Court of Appeals 354 SCRA 17, when it recognized the existence of the facility UP NSRI DNA Analysis Laboratory and expertise in using DNA test for identification and parentage testing. Although acknowledging that the test is still open to challenge being a novel scientific technique, the Supreme Court, in Tijing, categorically declared that, eventually, courts should not hesitate to rule on the admissibility of DNA evidence. Courts should apply the results of science when competently obtained in aid of situations presented, since to reject said result is to deny progress. Though it is not necessary in this case to resort to DNA testing, in the future, it would be useful to all concerned in the prompt resolution of parentage and identity issues. 4. 1 year after Tijing, in what could be considered as a landmark decision, the Supreme Court in People v. Vallejo 382 SCRA 192 2002, a rape-slay case of a 9-year-old girl, admitted in evidence the DNA samples of the victim which were found in the blood-stained garments of the accused. Vaginal swabs taken from the victim were also admitted and were found to show the DNA profile of the accused, who was subsequently convicted. Vallejo is considered by the court to be the first real breakthrough of DNA as admissible and authoritative evidence in Philippine jurisprudence. From a mere recognition of the existence of DNA testing, Vallejo moved towards an open use of DNA evidence in deciding cases. Vallejo adopted the following guidelines to be used by courts in assessing the DNA evidence. A. How the samples were collected, b. How they were handled, c. The possibility of contamination of the samples, d. The procedure followed in analyzing the samples, e. Whether the proper standards and procedure were followed in conducting the tests, and f. The qualification of the analyst who conducted the test. Bar 2009, 2010. In People v. Jansen 400 SCRA 584, the importance of DNA evidence was, likewise, recognized although the accused, who was charged with rape, was acquitted because of doubts as to who the real malefactor was. Here, the court lamented the lack of DNA evidence as a means to still the court's doubts. In Texan v. Komalek 424 SCRA 277, the court acknowledged the weight of DNA evidence when the court was faced with the issue of filiation of Fernando Poe Jr. Any doubt as to filiation or paternity, according to the court, would have been cleared up by a positive match through DNA testing. 5. Following the trail blazed by Vallejo, the Supreme Court in 2004 in People v. Yatar, 428 SCRA 504, May 19, 2004, relied on evidence, including DNA evidence, in affirming the conviction of the accused for rape with homicide when the test showed that a match existed between the DNA profile of the semen found in the victim and the DNA profile of the blood sample given by the accused. Yatar also made a lengthy discussion on DNA, the process of DNA testing and the reasons for its admissibility. Yatar significantly upheld the constitutionality of compulsory DNA testing and rejected the contention that it would infringe on the constitutional right against self-incrimination. The case significantly and clearly recognized DNA testing and the admissibility of its results as evidence. 6. A clear acknowledgement of the importance of DNA evidence is exemplified in the later case of In re Estate of Rogelio Ong v. Diaz 540 SCRA 480. The case originated in a complaint for compulsory recognition and support filed by a minor represented by her mother. The defendant, Rogelio Ong, died during the pendency of his appeal. Amidst the protestation of the estate petitioner for DNA testing because of the death of the defendant, the court, invoking the newly promulgated rules on DNA evidence, held that the test may provide the definitive key to the resolution of the issue, and even if the defendant had already passed away, biological samples could be obtained for the testing. Even the death of Rogelio cannot bar the conduct of DNA testing. The Supreme Court affirmed the judgment of the Court of Appeals remanding the case to the trial court for DNA testing. Rules on DNA evidence. 1. The rule on DNA evidence, referred to in this work as RDE, was promulgated by the Supreme Court through AM 061105 SC and, in accordance with Sec. 14 thereof, took effect on October 15, 2007, following publication in a newspaper of general circulation. 2. In what situation does the rule on DNA evidence apply? The rule on DNA evidence is the primary rule to be applied whenever DNA evidence is offered, used, or proposed to be offered or used as evidence in a. Criminal actions, b. Civil actions, and c. Special proceedings Sec. 1, RDE. When a matter is not specifically governed by the rule on DNA evidence, the rules of court and other pertinent provisions of law on evidence shall apply Sec. 2, RDE. 3. What is a DNA? B. DNA profile? C. DNA evidence? A. DNA refers to deoxyribonucleic acid, which is the chain of molecules found in every nucleated cell of the body. Sec. 31b, RDE. B. DNA profile is the genetic information derived from DNA testing of biological samples obtained from a person where such biological sample is clearly identifiable as originating from that person. Setsa 3 D, RDE. C. The totality of the DNA profiles, results and other genetic information directly generated from the DNA testing of biological samples is called DNA evidence. Sec. 3 C, RDE. 4. What is the significance of DNA? The significance lies in the uniqueness of the totality of the DNA of a person. It is a scientific fact that the totality of an individual's DNA is unique for the individual, except for identical twins. Sec. 3b, RDE. 5. How may an order for a DNA testing be obtained? Person who has a legal interest in the litigation may file an application for DNA testing order before the appropriate court, at any time. Sec. 4, RDE. The order for a DNA testing shall not, however, be issued as a matter of course and from the mere fact that the person requesting for the testing has a legal interest in the litigation. For the order to be issued, there must be a further showing that a biological sample exists that has relevance to the case, b. The biological sample I was not previously subjected to the DNA testing requested, or E, if it was previously subjected to DNA testing, the results may require confirmation for good reasons. C, the DNA testing uses a scientifically valid technique. D. The DNA testing has the scientific potential to produce new information that is relevant to the proper resolution of the case, and E, the existence of other factors, if any, which the court may consider as potentially affecting the accuracy and integrity of the DNA testing. Sec. 4, RDE. Finding that the above requirements have been complied with, the court shall now issue an order, if appropriate, to a. Take biological samples from any person or crime scene evidence, and b. Impose reasonable conditions on the testing to protect the integrity of the biological sample and the liability of the test results. Sec. 5, RDE. Note, the court may motu proprio order a DNA testing. Sec. 4, RDE. 6. Is a court order always required before undertaking a DNA testing? It is not always required. The last paragraph of Sec. 4 of the RDE allows a testing without a prior court order if done suit or proceeding is commenced at the request of any party, including law enforcement agencies. This also means that a litigation need not exist prior to DNA testing. Thus, a court order shall be required only if there is a pending litigation, but not before the litigation. 7. Is the order of the court granting a DNA testing appealable? It is not appealable and is immediately executory. Sec. 5 of the RDE clearly provides that an order granting the DNA testing shall be immediately executory and shall not be appealable. 8. What then is the remedy against the court order if it is not appealable? The remedy is a petition for certiorari under Rule 65 of the Rules of Court, but under Sec. 5, any petition for certiorari initiated therefrom shall not, in any way, stay the implementation thereof, unless a higher court issues an injunctive order. Sec. 5, RDE. 9. Is there an automatic admission of the DNA evidence obtained in the testing? There is none. By the terms of Sec. 5 of the RDE, the grant of a DNA testing application shall not be construed as an automatic admission into evidence of any component of the DNA evidence that may be obtained as a result of the testing. This necessarily means that the court will still have to evaluate the probative value of the proposed evidence before its admission. The determination of the probative value of the DNA evidence rests upon sound judicial assessment taking into consideration the following matters: a. The chain of custody, including how the biological samples were collected, how they were handled, and the possibility of contamination of the samples; b. The DNA testing methodology, including the procedure followed in analyzing the samples, the advantages and disadvantages of the procedure, and compliance with the scientifically valid standards in conducting the tests; c. The forensic DNA laboratory, including its accreditation and the qualification of the analyst who conducted the test. If the laboratory is not accredited, the court shall consider the relevant experience of the laboratory in forensic casework and its credibility shall be properly established, and d. The reliability of the testing result. Sec. 7, RDE. 10. If a person has already been convicted under a final and executory judgment, may he still avail of DNA testing? Bar 2012. He may still have DNA testing. The test after his conviction is termed a post-conviction DNA testing. Significantly, Sec. 6 of the RDE allows a post-conviction DNA testing. It may be available to a. The prosecution, or b. The person convicted by a final and executory judgment, provided that the following requirements are met: a biological sample exists, b. Such sample is relevant to the case, and c. The testing would probably result in the reversal or modification of the judgment of conviction. Sec. 6, RDE. 11. Is a court order required for a post-DNA testing? Sec. 6 of the RDE is clear. It may be available, without need of prior court order. 12. What remedy is available to the convict if the results of the post-DNA testing are favorable to him? If the results of the DNA testing are favorable to the convict, he may file a petition for a writ of habeas corpus with the court of origin. The court shall then conduct a hearing, and in case the court finds, after due hearing, that the petition is meritorious, it shall reverse or modify the judgment of conviction and order the release of the convict, unless his detention is justified for a lawful cause. Sec. 10, RDE. The petition shall be filed with the court of origin as a rule. However, the rule also allows the petition to be filed either with the Court of Appeals or with the Supreme Court, or with any member of said courts. A hearing may be conducted by the latter courts or by any member thereof, or instead of conducting a hearing, may instead remand the petition to the court of origin and issue the appropriate orders. Sec. 10 RDE. Note that under Sec. 10, the petition for a writ of habeas corpus may also be filed by the prosecution. 13. Are the DNA profiles of a person open to public scrutiny? They are not. DNA profiles and all the results or other information obtained from DNA testing are confidential. Whoever discloses, utilizes or publishes in any form any information concerning a DNA profile without the proper court order shall be liable for indirect contempt of the court wherein such DNA evidence was offered, presented or sought to be offered and presented. Sec. 11 RDE. Except upon order of the court, the DNA profiles and other results shall only be released to any of the following: a. The person from whom the sample was taken; b. Lawyers representing parties in the case or action where the DNA evidence is offered and presented or sought to be offered and presented; c. Lawyers of private complainants in a criminal action; d. Duly authorized law enforcement agencies; and e. Other persons as determined by the court. Sec. 11 RDE. The person from whom the biological sample was taken may also request that his DNA profile and all results or other information obtained from the DNA testing be disclosed to the person designated in his request. This request, however, must be in writing, verified and filed with the court that allowed the DNA testing. Sec. 11 RDE. 14. The trial court is mandated to preserve the DNA evidence in its totality, including all biological samples, DNA profiles and results or other genetic information obtained from DNA testing in accordance with Sec. 12 of the RDE. Paraffin tests. 1. Paraffin tests, in general, have been considered as inconclusive by the court because scientific experts concur in the view that paraffin tests have proved extremely unreliable in use. The tests can only establish the presence or absence of nitrates or nitrites on the hand, but the tests alone cannot determine whether the source of the nitrates or nitrites was the discharge of a firearm. The presence of nitrates should be taken only as an indication of a possibility, or even a probability, but not of infallibility that a person has fired a gun, since nitrates are also admittedly found in substances other than gunpowder. A person who tests positive may have handled one or more substances with the same positive reaction for nitrates, such as explosives, fireworks, fertilizers, pharmaceuticals, tobacco and leguminous plants. The argument that the negative result of gunpowder nitrates from the paraffin test conducted shows an absence of physical evidence that one fired a gun is untenable, as it is possible for one to fire a gun and yet be negative for the presence of nitrates as when the hands are washed before the test. People v. Kajumokan, 430 SCRA 311, People v. Bacongas, 417 SCRA 66. A person who uses tobacco may also have nitrate or nitrite deposits on his hands, since these substances are present in the products of combustion of tobacco. Revita v. People, 570 SCRA 356. 2. The negative findings of a paraffin test do not conclusively show that a person did not discharge a gun, if he fired a gun with a glove on, or if he thoroughly washed his hands thereafter. Besides, a paraffin test is not conclusive owing to several factors like wind direction, firing at a hard object, using a long barrel or a low-caliber gun and profuse perspiration. People v. Baltazar, 352 SCRA 678, People v. Galvez, 519 SCRA 521, see also People v. Buduhan, 561 SCRA 337. Polygraph tests, lie detector tests. 1. A polygraph test operates on the principle that stress causes physiological changes in the body which can be measured to indicate whether the subject of the examination is telling the truth. During an examination in which a polygraph is used, sensors are attached to the subject so that the polygraph can mechanically record the subject's physiological responses to a series of questions. 2. Courts, accordingly and uniformly, reject the results of polygraph tests when offered in evidence for the purpose of establishing the guilt or innocence of one accused of a crime because it has not yet attained scientific acceptance as a reliable and accurate means of ascertaining truth or deception. US v. Redder, CA4SC 801F2D 1437, 29 AMUR 2D Section 1007, People v. Rianzares, 334 SCRA 624. See you next slide. Thank you.